Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick, and I'm joined by the co-host, Seth Wilson. Seth, how's it going today?
Thomas, I'm doing wonderful. Appreciate the time. I've missed our last couple of weeks. We both had pretty busy schedules over the last couple of weeks with things going on. So, miss the midweek check-in is at least when we do our recordings. These obviously come out later in the week, but it's always good to catch up with you and see what's going on and swap some stories about the practice of law.
Yeah, it has been a couple weeks since we last did an episode. Took my family down to Holiday World down in Santa Claus, Indiana last week and enjoyed that. Yes, and I don't remember what happened the previous week before that. I've been missing doing the Lifetime Legacy Lawyer podcast with you. We've got a wide selection of topics that we could choose because they've been issued out of the blog posts on my website, vicklaw.org. The one that we kind of wanted to at least start with today is, what does an executor do or a personal representative do? That's just a wide open question, and I'll just let you start us off.
Well, it's funny that you kind of started it with what does an executor do, and then what does a personal representative do, and what does an administrator or an administratrix, or it's just a kind of a moving goal of trying to figure out what the actual term is. And so you may be familiar with that term from just either different experiences that you've had during life or been exposed to, but they all effectively mean the same thing. That individual who is in charge of marshaling the estate assets, creating that inventory, and getting assigned by the probate court with the authority to act on behalf of the estate. And so that first thing is, who is the executor or the personal administrator or personal representative of the estate, and where would you go if you're trying to find that information, Thomas?
Yes, so if there's a will, then your will probably says, you're nominating somebody to be a personal representative or an executor. In other states, it's probably more common to hear the term executor, but more often than not, the term that's used in Indiana wills is personal representative. And so you would go to the decedent's last will and testament, and there would be a section in there that states who the personal representative or the executor is to be. And from there, you would know that's me or that's somebody else. And that's really the person that should be filing a petition with the court to be actually appointed as personal representative. It's sort of a myth that if you've got a will and, let's say John Doe is named as the personal representative, the myth is that John Doe currently has the authority to handle an individual's affairs after the individual has passed away. But really what you're doing with the last will and testament is nominating that personal representative or that executor. And then that individual that's named in the last will and testament can petition the court to actually be appointed, and the court more often than not will appoint that individual as personal representative, so that and will do so because they're deferring to the decedent's last will and testament and the intent that's stated therein. So just because you're named as personal representative in the last will and testament, that doesn't give you really any authority. Once that individual has passed away, you've got to go to court and get authority that way.
Yeah, and I think that's a common misconception if you're not experienced in this world, and hopefully, you're not having to experience this position very often, because that's often a very challenging time when a loved one passes away. And so I think there's a couple just things I'd like to reiterate with that, and a practical kind of observation as well. So for example, with our will that we would put together for someone, we seal up the original into an envelope, and we actually put a wax seal on that envelope. And so those documents are intended to be the sort of proof of all the wills, and so you don't actually open that sealed will. And that's a common misconception as well. Now we open the will. Well, that's really the court's province if there is ever a contest to that will to determine what actually was the decedent's last will and testament. And so that'd be one thing I would say is if it's sealed up, don't open that will without talking to an attorney first and kind of getting the lay of the land. Obviously, if that's the only copy around and those kind of things, then you got to figure that out as well. But typically, that's going to be done in front of the probate court. And then the other thing that came to mind is just the idea of looking through all of the effects and trying to figure all of that out, and just don't really start taking action until you know that you're entitled to take action, because inevitably you will run into a scenario where something doesn't work. So a perfect example I think of that is if you're trying to sell the house, well, you won't have authority to sign the deed that transfers the title to that house unless you have been appointed by the court. And I see that pretty frequently in my practice, where most of the estate is sort of administered by someone, and then they realize, oh, I can't sell the house. Well, then now we have to go back and kind of recreate what was done so we can make sure that that accounting is done as well. So really, the best thing to do is to contact a lawyer right off the bat and just see if an estate does need to be open, because there's some rules about how that would work, and then just get some guidance on those next steps.
Yeah, and once that petition is filed and you've been appointed as personal representative, then your next step is to get the paperwork from the court. You'll get an order appointing you as personal representative of the estate, and then after that you'll also get letters of administration or letters testamentary that will be the document that financial institutions, title companies, things like that will be looking for to show that you actually do have the authority from the court to serve as personal representative and take action on behalf of the estate. And then, you're kind of, I sit down with my clients at that point in time and I talk with them about their specific assets that they know about. This asset, this house, you need to do this with the house, you need to do this with this bank account, and gather the assets. Liquid assets need to be placed into an estate account for safekeeping during the pendency of the administration. And that's one of the main things, is gathering assets, marshaling assets, as you say, and figuring out what creditors need to be paid off, and determining whether it's a proper claim that they file in the estate, or if it's not a proper claim that's filed in the estate. Do we need to disallow some claims? And so there's going to be a period of time where there's some indecisiveness because we're figuring out what's happening. We're kind of bringing some control to the chaos that is happening. And so that's sort of the next step. And those are general steps, but that's generally what I tell folks to do.
Yeah, and I think that's a really good piece of advice, because you're starting to, as your blog digest has said, manage those expectations for both the individual who is appointed either as the executor or the personal representative and the potential beneficiaries of the estate. Because it's not always okay, well, this happened and now everything transfers. We may not even know what needs to transfer or what assets will be available for transfer. Because as you mentioned, there may be claims against the estate that need to be paid first, and there's orders of priority and how that works. And obviously that's one of the most important reasons to get that estate opened up at an appropriate time, because it starts that claim period running. And if no claims are filed, then everything can be allocated as desired in the last will and testament as well. The next step that you reference in your blog digest is getting a copy of the death certificate. And that is something that typically can be done with the funeral home or through the county office. But that is really an important piece of the puzzle, because that document becomes evidence that can help support those claims. Even a lot of times, if there is a beneficiary designated account, that company, whatever that custodian company is, they will want a copy of the death certificate typically to pass along with the claim form.
Yeah, the one death certificates, and I think I usually have pretty good success with just providing a copy of the death certificate, but there may be some instances where an institution will want to see the original death certificate, and you may have to, pass it off to somebody for a period of time. And so that's why you want to get multiple death certificates from the funeral home. There's no real clear-cut answer on what the best recommendation is on that. Some people say, get 5 or get 7 or get 10. I'm not really sure, but get multiple death certificates from the funeral home so that you can handle whatever needs to be handled with financial institutions.
Yeah, and I agree with that. And we always kind of joke of the classic lawyer answer being, it depends. But that's really the key, because how many claim forms might need to be filed? We don't know that until we start going through the inventory. And sometimes you won't know that until you've been appointed the executor and now you're getting the mail. And so within a month, you may start seeing some bills come through that you didn't know about, or you may get a cable bill, for example, that you forgot about, and there may be a contract associated with it because it was some sort of satellite or something. And so those things will start to sort of come in over time and give you a clearer picture of what the entirety of the estate is going to look like. And so that kind of ties into some of the things you've already talked about, but making that list of the financial institutions, the life insurance, other assets that may be out there, but also other potential creditors and bill holders as well. And then I thought this was really important too, is contacting Social Security and any pension custodians, because that can cause some challenges. What have you seen in your practice if you fail to notify there?
Yeah, the problem with not notifying Social Security or other pension companies is that the payment is made, but they're not actually entitled. The decedent isn't actually entitled to that, after death. And typically, my understanding of it is, if a decedent passes away in June, they're not really entitled to the previous month's pay or the payment that they've actually received. You've got to survive through the end of the month to be entitled for that month's payment. And so paying back Social Security can be a frustration. Paying back a pension company can be a frustration because you got to wait on that payment to come in. And if you're not notifying Social Security in time or the pension company, and then if you get that payment, you've got to pay them back. And in the meantime, the account probably has locked up. And, if you have to open up an estate administration, that means you've got to go through a whole court process. It'll be several weeks. And then you got to tally up and make sure that you're paying, the financial institutions or Social Security back and the proper amount and all of that. So, and, usually we're not talking about a lot of money, but it is kind of labor intensive sometimes if we don't catch that Social Security payment in time.
Yeah, and it's an unpleasant surprise if you had access, or maybe you were the joint account owner with mom or dad, and they passed on. All of a sudden, that account balance changed on you from day to day, and you weren't expecting that payment that came in to be taken right back out. And this is, I kind of joke about this sometimes, because this does seem like one area where the federal government does move quickly with respect to these types of payments. They will take those funds back as soon as they know. And that may not even be you notifying them. They may have been notified by some other system, but as soon as they find out, boy, that payment is out of that account because of those reasons you just talked about, the risk that it could take them several weeks to get repaid, and they're pretty tight with how that money works. So, yeah, something to be aware of there as well as you're thinking through that. And then your next point I found pretty interesting because this is a whole new-ish area to the law, right? These digital assets, and this could include something like cryptocurrency, which is a whole podcast probably topic in and of itself. But just the facts of trying to access someone's digital life, their email account, their online banking accounts, their logins to the utility company, because maybe they get electronic bills for all of their utilities now. How do you get access to all of those things to really carry out the responsibility you have as the personal representative?
Yeah, and we've had some experience with this where maybe we needed to get access to a decedent's email inbox or text messages and kind of figure out maybe what was happening in that individual's life. Maybe there's some events that need to be investigated by the personal representative, or maybe we just need to figure out what online bank statements are coming in so we know what financial institution to go to find the individual's assets. And so there are proper reasons for getting into a decedent's email, but there are also some pretty severe restrictions. Google has its own restrictions, Yahoo, Outlook, all these different email servers or what have you. They have their own system and their own rules that you agree to when you sign up. So part of it is complying with their rules, but then also you might have to cite, and I can't remember exactly the acronym, but there's a whole section of the Indiana Code that will kind of guide you through the process of getting a court order and then being able to take that court order authorizing a personal representative to obtain the digital assets. And so you may have to go through that specialized process to actually present that to the big name Google or Yahoo or what have you, and then be able to search through that. And email is just one of them. And this is why we encourage people to have a plan to pass down usernames and passwords in a confidential, secure manner so that the loved ones coming in after you have a way of getting to what they need to get to with instructions from you.
Yeah, that's such an important point, and there's a variety of tools for how to do that, but there's not a whole lot that can beat pen and paper in this scenario at the very least of keep that document, in your estate planning binder, if you will, that has access instructions to, hey, here's where I go to pay the water bill, here's where I go to pay the gas and electricity and those types of things, so that if there are automatic withdrawals coming out of that account to pay those bills, those can be reallocated appropriately, and or the service is discontinued if that's what needs to happen at that point, right? So it's just good to keep organized on that regard, and especially, as you mentioned, that confidentiality and security with passwords, and they change so frequently that this is kind of a continual process that you'll need to go through to ensure that your loved ones have access to what they need with the least amount of administration possible. And that's where, as you were mentioning, it gets so challenging from the probate process, because if we need to get the court's authority to do something, we have to file a petition. You got to wait for the court to review the petition and grant the petition, and then you got to submit the petition. And what if it's missing a required piece of information because Google, Microsoft, whoever required this one more magic phrase before they're going to unlock the account? And so it can just add to the cost and really the stress, I guess, of the administration, all of which can be obviated by just leaving clear instructions.
Yeah, for sure. Another point to be made as far as what an executor does is contact the HR department of the individual's workplace if they were still working, because there may be some unpaid wages that need to be paid out to the estate, and that may be something that that you need to look into. So that may not be something that you think about. You're kind of thinking about the bigger assets, but there may be a paycheck or two that still need to be paid out to somebody.
Yeah, I think alongside of that is consider if there's any type of military service or benefit that might be available and reach out to the VA in the jurisdiction where you are to make sure that if there are some sort of burial benefits or even presentation of colors or those kind of things that would be part of a thank you for the service of that individual, it's good to make that call and see what's available.
Yeah, for sure. And then the last one, people shouldn't be surprised by this. Don't be averse to getting professional help. And, you know, you and I, Seth, we do estates all day, every day, almost. We're well familiar with the steps that need to be taken to help individuals and families out through this kind of process. And, you know, my suggestion is it will only be harder if you don't use professional help. And that's not just limited to attorneys, but it also extends out to CPAs. It extends out to the decedent's financial advisors. They're in business. Maybe you need to talk to somebody about, you know, what's happening in the decedent's business. Maybe talk to the partners in the firm or whatever the case might be. So, you know, seek advice and take the advice whenever you get it.
Yeah, it's such an important point. I mean, that's why people do what they do, right? And they have the experience to know this should be pretty straightforward. We can walk you through it, or no, you're going to need to watch out for this little thing that you might not be thinking about. But I think that underscores the importance of that team approach. If there was a team of advisors helping during life, that same team can be helpful now that the time to transition those assets is here. So the financial planner can help with those beneficiary forms. They're going to be familiar with how their particular system works and what kind of information is going to be needed. The CPA can be super helpful on the tax questions and how do you do valuation of assets? Do you have to worry about those kind of things? And the attorney obviously can help you navigate the probate process. And so, again, that team of advisors is always helpful at that time. And you know, don't forget that this is an emotional time a lot of times, and so you may not be able to do it all at one time, and it's okay. You know, I think there is some help in the grieving process by being forced to address some of these things at certain points in time. But once the flow of the estate starts happening, it's less of an overwhelming thing and it's more handling things as they arise. And so each time you're sort of forced to work through that, it can actually help with the healing process a little bit as well. And so long as everybody is getting along, then hopefully that's a smooth process. If there's some challenge to how things are supposed to proceed, that's again a whole nother whole nother conversation. And unfortunately, from time to time, we've been involved in those scenarios as well.
Yeah, and I fully agree with you when it comes to the stressful situation that going through an estate administration presents. There's a lot of stress, a lot of emotion happening in an individual's life outside of the legal process. And, you know, I try to keep that in mind when I'm talking to personal representatives because, you know, they ask me the same question 2 or 3 times, maybe 4 times. And, you know, I've answered it maybe a week ago, but you need reminders. And, you know, I just kind of have to remind myself of what the individual is going through and just be patient through that and have some understanding and compassion through that situation. But yeah, but I think seeking professional help is the best way to do it. That they can kind of ease the burden for families during that situation, and they can also tackle, you know, some black sheep of the family that arise from time to time. So, and walk you through those situations. So that does it for the list. We had 8 things that an executor does. There's certainly more to it, but that's a little bit of a summary, a little bit of a bulleted list. I encourage people to to take a look at those blog posts on viclaw.org. That's the best way to get in touch with me as well. Contact me at viclaw.org. You can book a call through there and set up a Zoom call or a phone consultation, and we can help you out. I'm on the south side of Indianapolis. Seth, how can people reach you?
Thomas, we are located in the heart of Hamilton County here in Noblesville, Indiana, and that's our web address, noblesvilleattorneys.com. And that's the easiest way to get a hold of us. So appreciate the time today and hope you enjoy the rest of this afternoon.
All right. Thanks, everybody.